Good afternoon, my Lord. My Lord, Lord Burrows.
Paragraph 49.
Sorry?
Is it paragraph 49?
Yes, that was my question to you. Yes, paragraph 49. And the answer, my Lord, is paragraph 95 of our written case.
You want to elaborate?
Yes.
Especially for the rest of this.
Your Lordship issued a cryptic challenge and you got a cryptic answer. I apologise. You're referring me to paragraph 49 of Lord Justice Patton's judgment in ITS and Noble, which is at page 1506.
1506.
1506. And we can pick it up at 1505. Where at paragraph 47, four propositions concerning the operation of the bona fide purchaser rule are put. They're credited to...
Sorry, paragraph what, sorry?
47.
47, thank you.
On 1505, four propositions concerning the operation of the bona fide purchaser rule are put. And if your Lordships would like just to read those, they're unsurprising.
Wilkes and Spooner.
So it's 3 and 4 that are really in play for the point that Lord Burrows raised with me. And then we go across to paragraph 49, where Lord Justice Patton said that he had no difficulty with the first 3 propositions, but that in relation to fourth there was a qualification, and that was that, as Lord Justice Vaughan Williams had said in Wilkes and Spooner, but has been picked up in McGarry and Wade, an established exception exists in the case of an actual or constructive trustee who subsequently reacquires the property from the bona fide purchaser. In such cases, the original title of the beneficiary is not permanently extinguished by the sale to the bona fide purchaser and is either revived or remains enforceable against the trustee. And we would emphasise, or remains enforceable against the trustee. Now, the way our response in relation to this at paragraph 95 of our written case was that this is a wholly unsurprising exception. I mean, the reference to actual or constructive trustee there, is to a true trustee.
Ah, right.
Oh, okay. Yeah.
Could you repeat that last point?
Yes. Is the reference to an actual or constructive trustee is to a true trustee.
Which reference?
In 49, the fifth line.
Yeah. So it's that kind of constructive trustee who's a trustee de Santor or
exactly
an intermeddler.
Yes. What it's saying is, as we explained at paragraph 19 of our written case, is that if you are someone who has had trusteeship reposed in you, or you've assumed trusteeship constructively so that your position is equivalent to a person who has had trusteeship reposed in them, then should the property come back, your conscience is, as it were, affected by the fact that you're a trustee in respect of that property. And should the property, having been diverted through third, fourth, fifth parties' hands, including bona fide purchasers, come back to you, then of course the fact that you're conscience bound in order to recognise your trusteeship in relation to that property has not been extinguished. And that is the exception, and it is the sole exception, that has been recognised at paragraph 49. And
so you're recognising an exception based on conscience in one case and denying it in another.
No.
I mean, what about the person who, let's say A is the bona fide purchaser for value, who then transfers it to B, who knows that that A has obtained property which was what was in breach of trust, albeit A's title was a good one because he's equity's darling. Why is B's conscience not affected?
Because there's no pre-existing relationship. That is the point, 47.3.
So what do you mean by no pre-existing relationship?
There's no pre-existing relationship pursuant to which the conscience of the individual has been bound to recognise the equitable interest. It's the proposition at 47.3 of 1505.
Yes, that is proposition 3, but I'm just wondering why in principle is proposition 3 correct?
For the reasons that are given by Lord Justice Patten at paragraph 45, endorsing what's said at McGarry and Wade. This is, whether your lordships agree it or not, this is an absolutely fundamental tenet on which the rules of bona fide purchase work. But if your lordship goes back to 1504 to 1505, paragraph 45, it's absolutely established that for reasons of certainty of title, for reasons of certainty of dealings, once a bona fide purchaser has intervened, then subsequent dealings can be taken free. Otherwise, people would be constantly looking over their shoulders.
It's a certainty. It's a contrary policy.
Exactly.
Impetus, as it were.
Precisely. Yeah, and it would be a crazy situation.
And certainty of dealing may outweigh conscience.
Exactly.
Yes. Okay.
Thank you. But whereas the answer to paragraph 40, given at paragraph 49, is absolutely right. It would frankly be monstrous if your conscience has previously been bound to recognise trusteeship in relation to this property, and you were to say to the beneficiary, "Sorry, I've taken it free. I've taken it free as a volunteer. I've taken it free of your interest because someone else bought it in the meantime." That would be wholly unacceptable, and it's been recognised as unacceptable for over a century.
Paragraph 45 explains principle 3.
Precisely, my lord.
Thank you very much.
Thank you.
By reference to McGarry and Wade.
Sorry?
By reference to that passage.
By reference to McGarry.
Which in its turn is based on Wilkes and Spooner.
And you said we got some confirmation of it, paragraph 55, did you?
No.
Oh, I thought...
45.
45.
Oh, if it's only 45, that's fine.
Yeah.
So I thought you were reading ahead.
1505 was the page you referred to.
Yes.
Right. Thank you.
So the authority, I've forgotten the name of it, is it Stopford or something similar, where a trustee reacquires?
Exactly.
Where's that in your case? I can't just find...
Paragraph 95, page 137.
Paragraph 95.
It has to be a true trustee as opposed to as if a trustee.
Yes, my lord. Well, so far as this principle goes, yes. If you're someone whose conscience has previously been bound,
Yeah,
yes.
it would apply to as if a trustee.
Yes.
Yeah.
Whether, excuse me again, whether there may be situations where a knowing recipient has taken a property in circumstances where his conscience is bound, and then the property goes around in circles and then it comes back to him, one might imagine that sort of situation might be treated in the same way as this. Yeah? One can see, actually, now I articulate it, you can see why as a matter of policy it would be, but it doesn't affect the result in this case. So suppose you've got a knowing recipient, your lordship's got the point, yeah. Suppose you've got a knowing recipient whose conscience was bound and he transferred the property away, and the property went through bona fide purchasers, and it came back to the known recipient, he would then be under an obligation to restore that property. Right. The fact is, transferring it away won't have excused him from liabilities generally, but as regards the obligation to restore the property, that will have rekindled. Why not?
So this is actually no more than a recognition of that authority in your submission.
Precisely.
I think, yes, that's helpful. Thank you very much.
Oh, thank you. Macmillan. Now, As your lordships know, we introduced Macmillan at paragraphs 30 and 31 of our case. That's pages 119 and 120, and at paragraphs 115 to 129, that's pages 143 to 150.
Sorry, I didn't hear either of those.
Sorry.
Sorry.
So if you could project your voice a little bit more, please.
No, I apologise.
Yeah.
So we introduced Macmillan at paragraphs 130 at paragraphs 30 and 31 of our case. That's pages 119 to 120. And then we undertook a more detailed treatment of it at paragraphs 115 to 129, and that's pages 143 to 150. And the first point I'd like to make in relation to Macmillan, if I may, is that it is important to keep in mind that, as is apparent, and I will further make good in a moment, Macmillan were bringing both proprietary and personal claims, and that the defendants were therefore looking to invoke the law relating to priority of title to defeat both sets of claims. It would not have sufficed the defendant's purposes to have attempted to rely on insufficiency of knowledge alone, since that would have left them exposed to Macmillan's proprietary claims. They needed, under either of the candidate laws of priorities, to get home on bona fide purchase for value to see off Macmillan. That's to look at the matter from the defendant's standpoint. From Macmillan's standpoint, it was seeking personal as well as proprietary relief. And to that end, as we note at paragraphs 128.4 and 128.5 of our case, pages 149 to 150, to that end, as is apparent from the epilogue at 547 to 548 of your bundle, page 1015H to 1016B, to that end, Macmillan had indeed set itself the task of proving knowledge on the part of defendant third parties that the shares had been held on trust for it, a constituent ingredient of knowing receipt, but not of a proprietary claim. So, Macmillan was attempting to establish knowledge to make good its personal as well as its hard-nosed proprietary claim, and the third-party defendants were attempting to establish bona fide purchase to defeat Macmillan's personal as well as Macmillan's hard-nosed proprietary claims. The appellants fasten on the significance of bona fide purchase to the issue before the court, but the centrality was not based on any failure of understanding as to knowledge supplying a relevant standard of personal liability. Mr. Roxburgh has kindly pointed out to me that I gave the wrong reference to the epilogue. It's 457.
It's 457. You inverted the 5 and 4.
Thank you. Apologies. Right. Okay. So the fact is, each party had its own axe to grind, and in order effectively to grind it, the defendants needed to say your title has been snuffed out, and the claimant needed to say, proprietary claim, I still have title, but furthermore, personal claim, I had knowledge. Now, second point, and I've made this more than once, but it's apparent from the extended treatment by Mr. Justice Millett at pages 988D to 990E, so that's 430 to 432.
Could you give me the pages again, please?
So sorry.
Again, I do ask you to keep your voice up. I don't know if I'm the only one having difficulty.
No, I'm sorry.
Yes.
I'm sorry. It is apparent from the extended treatment by Mr. Justice Millett at 988D to 990E of the report, that's 430 to 432, that a third-party claim in equity is, without distinction, being stated to require a continuing equitable proprietary base. That is, an equitable interest to which the third party has taken subject, which has not been overridden upon the third party's acquisition of property. Indeed, and I'm going to take you to references generally, but if I may take you to a specific one, at page 430 of your electronic bundle,
Yes.
at 988E, Macmillan is recorded as having advanced an argument which might be said to be that of the appellants in this case. Macmillan said, and it's 2, 4, 6, sort of 8 lines down, line beginning principles, but it's the sentence I'm interested in, even its claim to the return of the Burlet shares or their proceeds in specie it submits, which can loosely be described as proprietary, was in truth no more than an invocation of the power of a court of equity, acting in personam as a court of conscience, to require the defendants to take whatever steps were necessary to restore the shares to Macmillan's ownership.
Why did he use the words loosely described as proprietary? Is that a reference to, in equity, all claims are personal?
In this particular respect, they are saying that the claims in question, whose characterization is in issue, are personal claims. Yes. And they're saying, although they clearly concern property, and so in that sense may loosely be described as proprietary, nonetheless they are Ewing-based claims. They are claims where you are saying that someone is in conscience, in personam, bound to restore. That is, we say, a knowing receipt claim. Now, so far as regards the references in Macmillan generally, which we which we invoke, the fact is that the ingredients of a claim in knowing receipt did not receive any particular attention in Macmillan. But the truth is, the ingredients of a proprietary claim did not receive any extended treatment, in fact, any treatment in Macmillan. The focus of the judgments in Macmillan was not, at least as reported, and you'll recall that we all struggle with the fact that Macmillan at first instance is an edited version of what undoubtedly will have been a monster of a judgment, having regard to the length of the trial, but the edited version point comes from 423, just below letter C.
What is a proprietary claim in this context, if it's not a claim for return of the shares?
Well, a proprietary claim is, well, you put your claim in two ways. You say, those are my shares, hand them back. Or you say, in personam, you are obliged to restore them to me. And this is there's a great deal of confusion has arisen in relation to this. You've seen, we've referred to it in our case. the two remedies track one another. You know? But because it may be that this is a further feature of the discussion that I was having with Lord Burrows this morning, that because of a reluctance to describe someone who's holding property without knowledge as a trustee of that property, you know, knowing receipt has been treated as really the way of getting to a duty to actually restore inequity which is actually imposed on someone. And so the hard-nosed proprietary right is seen as no more than snapping your fingers and saying, I'll have that back, it belongs to me in equity. Whereas knowing receipt involves the imposition of duties, a duty to restore and consequences for failure to do that. Knowing receipt, if you like, has consequences, whereas the proprietary claim is plain vanilla. But they do track one another, and it is undoubtedly a source of confusion. One source of confusion in this area is the discussion we had this morning. It is the Lord Brown-Wilkinson point. Another source of confusion is the tracker point. But there is no doubt that the imposition of duties under English law depends on knowledge, and that's where the departure occurs. And it's a reason for perhaps some confusion as to what's going on in Macmillan. I fully accept that. Now, so far as regards the references in Macmillan...
Well, in a hard-nosed, what you call a hard-nosed proprietary claim, isn't it still equity dealing personally with the person who's received the property?
Well, it's making...
as opposed to recognising a proprietary claim.
No, forgive me, my lord, in a so-called hard-nosed proprietary claim, it's equity saying we recognise that the equitable title to the property remains vested in the claimant, and that, without more, is a basis for the claimant to say that's my property and to call for it back. It's not obviously an order it's going to be against a person, whether it's natural or incorporated, but it's not that. In that sense, equity is not acting in personam. It's not conferring a personal right. It's if you like, a litmus test of this is the fact that equity does not attempt to make proprietary orders in relation to land in foreign jurisdictions over which the court does not have jurisdiction, even though the target of the order would be a person.
But I mean, the equity acts in personam. We've had this quoted to us repeatedly.
Yes.
So it does not a proprietary claim arise out of. Does not arise out of the personal rights that equity gives you?
Well, my lord, for the purposes of the present discussion and present terminology, yes, fine. There's no. I'm agreeing it because I mean it possibly is right with respect, because it doesn't really affect the present question. Yeah. How you rationalise the basis for equity recognising a proprietary claim against someone does not really determine the present question. Yeah. Yeah. But I fully accept Lord Leicester's point that there is a scope for confusion because the two remedies are going hand in hand and tracking one another. But the difference is that in the case of knowing receipt, the remedy reflects the imposition of a duty which is based on knowledge, whereas in the case of a proprietary claim, the remedy reflects simply the fact that it remains your property. And that's it. And consequences follow from the existence of the duty in the case of knowing receipt, which do not follow from the simple existence of a proprietary claim.
Okay. Is the point about equity acting in personam, one's in a sense pushing that off, is that because effectively that's a jurisdictional question?
I think...
for our purposes.
Precisely, for our purposes. And it's the point that I was making this morning, but I can't make it more strongly enough. the point I started making by reference to paragraph 24 of Akers, and the point I was making in relation to lightning. Equity is acting in personam in these cases, and whatever the limits of equity acting in personam for present purposes, let us say for the sake of discussion that it includes the making of proprietary claims, so be it. Whatever the limits, whatever the limits of the extent of the in personam jurisdiction as regards remedies, what's recognised in Lightning and what's recognised in Akers is that the lex situs supplying an overriding basis for the extinction of title is a defence. And I repeat, the claim in Lightning was an in personam claim because we were dealing with foreign land over which the English court did not have jurisdiction, and the limits of such a claim were being described by the Court of Appeal. And in Akers, we're talking about in personam claims. Lord Mance tells us that that's the basis upon which trustees are recognised as having obligations even though they're holding foreign property, so be it. The limits on such claims are being expressed, are being described by the Supreme Court in unmistakable terms, in that case by reference to the intervening overriding effect of the lex situs.
If equity acted in personam on the conscience, it would solve the tracing problem going through civil jurisdictions, because as soon as the money came back into this jurisdiction, the conscience of the person would be affected, and there you are. That's the end of the case. And but that is a solution that doesn't sit easily with your argument, namely that the title is lost whenever it's combined, as it were, in a civil jurisdiction. A civil jurisdiction doesn't recognise a beneficial interest.
A civil jurisdiction which has the effect of extinguishing the title. That's correct, yes. Because we say that's the difference between the parties. What one party is saying, it's sufficient to say that your conscience is bound. The other party is saying, no, you've got to establish a continuing equitable interest, and your conscience can't possibly be bound in circumstances where the equitable interest was extinguished, because the rules which govern priority of title have determinatively resolved the question.
It's sufficient for your purpose that what makes the retention unconscionable depends on the person making the claim having some sort of property interest at the time the claim is made. Whether that's a property interest which has always been there or it's gone away and come back again, for your purpose doesn't really matter as far as I can see, because we're dealing with a jurisdiction whose law doesn't recognise any form of property interest, and so there's nothing on which to base the claim.
That's right. I mean, the only qualification I make to what your lordship said, and I don't think your lordship was saying anything different, is that the important point is that you don't necessarily have to have the equitable interest at the time that you make the claim. You have to have had the equitable interest when the knowledge was obtained. Because yes, the property may have been dissipated. But I know what your lordship was saying.
Exactly.
Yes, I know. Thank you.
But your point is that it comes back to independent trustee service, that the rule is that once a bona fide purchaser for value has acquired title, then the interests of certainty of title prevails over questions of conscience, and you say that applies equally when something goes into a foreign jurisdiction and the equitable interest ceases to exist.
Exactly, my lord. And I mean, that applies generally, and specifically in this case, on the facts of this case. Because if I can just draw your... Well, we will come back to Montague, I promise. But as regards this particular point, if I may just find in my notes what I wanted to say to you about it. This is an important point. It goes to the importance of the lex situs in relation to the issue in this particular case, because obviously a casual response to what I'm saying is The lex situs may say you've got absolute title, but why should that affect your conscience? Why shouldn't your conscience be bound? And clearly that's not the law, and that's not how it operates. The law is that you've got to demonstrate unconscionability of retention of the benefit of the property, and the position is that you can't possibly have unconscionability of retention if the title has been extinguished. But I just want to make the point to you in relation to the importance of the lex situs generally here, and specifically in relation to previous findings in this case in relation to the law of Saudi Arabia, if I may. Very quickly, we dealt with the lex situs and its importance and significance at paragraphs 39 to 49 of our case. That's pages 123 to 125. And as was noted there by reference to the Glencore case, the importance of recognising the lex situs as being determinative of questions of title and priority of title accords with, first, the natural expectations of reasonable persons. Two, it provides security of title in property transactions. And three, reflects practical realities of control of property. So, the general point here is that the application of the lex situs to determine questions of title and the recognition of its effect is of fundamental importance in supplying certainty to people in their dealings, commercial and personal alike. And having firm rules for establishing title and priority of title, whatever their source in relation to a given asset, enables people to go about their business with confidence and is essential to dealings in a sophisticated society. Now, that's the general point. Specifically, the position in Saudi Arabia in relation to the conclusiveness of title, pursuant to registration on the Saudi Arabian share register, the Tadawul, was the subject of specific findings below. And I just want to refer you to a couple of very short passages in the Court of Appeal's judgment and in relation and in Mr. Justice Fancourt's judgment, if I may. If we may first go to the Court of Appeal, it's paragraph 84, which is at page 186. And it's simply the point. There's an explanation there of the way in which the Saudi capital market regulation operates in conjunction with the Securities Depository Centre. But the particular point is 3/4 of the way down the paragraph, the line which begins the SDC, just below the 21. Article 27 of the Capital Market Regulation provides that all transfers of listed securities are to be registered in the records of the Securities Depository Centre, and that such registration serves as, quotes, conclusive evidence and proof of ownership. And then if you look at 89, at the concluding observation of the Court of Appeal, at page 187, recording what had been found on the evidence of the experts. The final sentence, to admit claims based on extraneous dealings would undermine the whole basis of the authorised registration system reflected in the purposes set out in Article 5, one of the originating provisions of the Capital Market Regulation. And then, if we could just flick back to Mr. Justice Fancourt, his judgment at paragraph 197 at pages 258 to 259, please. and this is what was reflected in the paragraph 89 quote that I gave you. Just picking it up 6 lines down, I find that Mr. Heberbeck must be right that it would not be credible for a claimant in Sickles' position to be able to rely on an off-market transaction with a registered proprietor in order to assert ownership of shares, which would then be capable of binding a purchaser in an authorised transaction through the SDC exchange, who has obtained registered title to the shares. Such a possibility would undermine the credibility of a system of authorised dealings in shares that is transparent, efficient and secure, and be contrary to its objectives, which are amongst others. And the objectives are then stated, and the final sentence of that paragraph: it is clear from the rules that any interests that affect a proprietor's registered title are to be noted on the register, not hidden behind the curtain that registered title designedly provides. So this is a case where the equation of the registration provisions under the Saudi Arabian share, in the Saudi Arabian share stock exchange, are in merit equivalent force being recognised in relation to them to the bona fide purchase rule. It is as though you had a registered land provision, which we say you actually do have in this country, but I don't think your lordships need to get into it. It is as though Section 29 of the Land Registration Act 2002 had said, which, as I say, we think it does say, if you've got having registered title is the functional equivalent of having legal title, an absolute title against which no claims can be made unless there's a subsisting equitable interest which is binding on you by virtue of it being an overriding interest or whatever. It's as though you had an absolute bar under a land registration system. That absolute bar has been found as a fact in this case in relation to the Saudi share register. And we say casual references to conscience don't come into it. The conscience, frankly, doesn't come into it. And your lordships will have seen. Forgive me. Let me just finish this point because there are so many points, and I'd like to deal with this. Your lordships will have seen in our written case that we make reference to Midland Bank and Green and to Lloyd and Dugdale. And the point which comes out of those cases, and it's dealt with in our written case, but the point that comes out of those cases is that it's not unconscionable to rely on the provisions of a registration system. You can't turn around and say, well, you knew, therefore the absolute protection which is otherwise provided to you under a land registration system is to be set aside in personam, in equity, by the imposition of some constructed or constructed remedy in relation to you. You can't do that. And as Sir Christopher Slade explained in Lloyd and Dugdale, you have to be very careful to distinguish cases where the equitable interest has been extinguished because the register says so, from cases where separately the recipient, the transferee, has assumed an obligation on the occasion of registration, which, if you like, has either given rise to a new equitable interest or which involved an express undertaking on his part that he would acknowledge the existing equitable interest even though it has been extinguished by the register. And this is paragraphs 60 to 62 of our case at electronic bundle 128. And that's English law. I mean, that's English law now. There were brief excursions, as your lordships may be aware. There was a case of Mr. Justice Graham called Pepper and Rig, which had a brief celebrity for suggesting that you could have a constructive trust behind the register, which has been firmly squashed. It's a historic interest. But Midland Bank and Green, Lloyd and Dugdale, are where English law stands in relation to this. So, back to Macmillan and the indicia, so far as we say, of the fact that notwithstanding, as obviously we accept, the references to knowing receipt were not spelled out, ingredient requirements of knowing receipt claims were not articulated, obviously we accept all of that. Nevertheless, the indicia in the case are that that only game in town was the game that was being played. And we start with the references to the writ, which are at page 422. Page 422, and the contents of the writ is that are described between G and H. The writ, as re-amended, claimed, 1, a declaration that Macmillan remained and still was beneficially entitled to the 10.6 million shares. 2, an order that BIT should restore and account to Macmillan for the 10.6 million shares, and an inquiry as to A, the proceeds of the use of any such shares other than on behalf of Macmillan, and or B, compensation by BIT for breaches of trust. A declaration that the following shares were held on constructive trust for Macmillan. And then over the page, B to C, the writ sought such orders as were required for preserving and restoring to Macmillan the shares and all dividends, distribution, voting and other rights appertaining thereto, and the certificates and records relating thereto, and the proceeds thereof, and for tracing their whereabouts, etc. As re-amended, the writ also sought against Shearson Lehman, Swiss Volksbank, and Credit Suisse compensation and or damages for breach of constructive trust and or conversion, payment of all sums found due, together with interest thereon, pursuant to the court's equitable jurisdiction and or section 35A.
That's interest.
Pardon?
That's interest pursuant to the equitable jurisdiction.
Oh yes, that's I get that, Lord.
Yeah.
But yes.
But they covered everything you can think of, as usually happens in a case like this with a claim form.
Yes, including not forgetting something called a knowing receipt. Yeah, we would say. I mean, the language, with all due respect to those wishing to adopt a restitutionary classification in this case, and with all due respect to the potentiality of use of unjust enrichment language in relation to what's going on in this case, this is not the language of the English law of unjust enrichment as identified by Lord Burrows in the restatement. This is the language of compensation and or damages against a third party for breach of constructive trust in failing to restore the shares, yeah, and or dealing with them in a way inconsistent with your interest. This is a constructive trust claim against third parties who are recipients. What is that? It is a knowing receipt claim insofar as it's not based on property alone. In our respectful submission, there's no getting away from that. And then it's sound bites. I accept this and I ask your indulgence in relation to it. At 425, between F and G, Macmillan seeks both proprietary and personal relief. If I understand sort of my learned friend correctly yesterday, that the appellants are still wedded to this mantra in relation to Macmillan, that it was a proper proprietary claim case. It's a proprietary claim case. You don't need to worry about anything else. It's plainly not. It was a case where personal relief was also being sought. Claiming restitution of the proceeds of sale of the shares and equitable compensation for loss. And then 430.
I was originally tempted to think that if in fact they got the shares, the defendants have still got the shares when the writ was issued, then even if personal claims are being made, it was in reality a proprietary claim. But I suppose you'll tell me, well, yeah, but that's the same situation in this case, because Samba still had the shares when this claim was introduced.
Yes.
It's solely a knowing receipt claim.
Yes, well, on that hypothetical, it's a complete analogue to our case. In fact, it seems that they didn't have all the shares.
No, well, I was going to wonder about that and where one find the detail of that. Probably can't.
No, I mean, I think the parties, certainly we as parties, made exhaustive inquiries as to whether there was a version of this judgment in Lord Millett's papers, which was unedited, and unsurprisingly, that didn't turn up anything. Oh, but I have the benefit of Mr. Roxburgh, who, thank you, Anna, who draws my attention to page 425, which is the page we were just looking at, between C and D. As that says, actually, it was in fact, my learned friend drew attention to some of this, and I have got it marked up. Since the commencement of the trial, and with the cooperation of all parties, the 5.8 million shares held by these defendants have been sold in cash and other consideration. The question for determination now is whether Macmillan retained an interest in the shares superior to that of any of the defendants and is accordingly entitled to a corresponding part of the proceeds of sale. But that's only part of the story, I think, because they're claiming compensation for loss also. Anyway, on to page 430. Between D and E, I've just referred you to that passage, in personam, obligation to restore, and then in the generic description of the kinds of claims with which the court was concerned, at the bottom of page 430, where this is, I accept, all part of the general discussion of the different categories of case. The distinction is that drawn by equity between the claim of an equitable owner to recover the property or compensation for the failure to restore it from a person into whose hands it has come. So restoration-based remedies are clearly in mind in this formulation, and it's no surprise to see that at the end of that paragraph, knowing receipt is being referred to in connection with it. And you then see on page 431 between B and C that the recognition that this is a first category case, there is no equity between Macmillan and any of the defendants. In the absence of such an equity, any liability of the defendants to restore the shares or their proceeds to Macmillan or to pay compensation for their failure to do so must be based upon Macmillan's continuing equitable ownership of the shares. And then we can leave Mr. Justice Millett and just pick up a few references in the Court of Appeal, please, starting at 470. And there's the reference between G and H, Mr. Oliver appearing for Macmillan. So this is just the end of that paragraph. Mr. Oliver points out that Macmillan claim not only a declaration as to their proprietary rights, but also an order that the defendants restore the shares to Macmillan and compensation for damages.
All damages.
Well, is that what is that? I ask, if not a claim in knowing receipt.
So it says and compensation, or is it and compensation or damages?
Yes.
Yeah,
So,
but
I mean, you'd have thought if you restored the shares, there wouldn't be a compensation or damages claim. It's performance of the obligations imposed on the recipient or damages for breach.
well, you may easily have suffered loss in the meantime if the shares could have been restored earlier and then they could have been
Or there
realised.
may be custodial failures, I suppose,
Yes.
as well.
Yes.
And there may have been dividends paid.
I'm so sorry.
There may have been dividends that
Oh
need
yes.
to be accounted for.
Yeah. Well, that.
Yes, okay.
Yes. Yes.
Have similar orders in the proprietary claim.
Well, precisely. That's why I hesitated in relation to that. But what is clear is that, but also an order that the defendants restore the shares to Macmillan and compensation or damages. but also alongside declaration as to their proprietary rights. This looks very much like a lightning claim, to be perfectly honest, but tacked on. Yeah, a declaration, lightning, you hold Scots land on resulting trust, and then an order, lightning, restore the land to me. But also further distinct knowing receipt type orders in relating to compensation or damages. So because lightning wasn't...
You get all of that in a proprietary claim.
Well, it depends what you call a proprietary claim, doesn't it? I mean,
yes.
The usage doesn't seem to be consistent.
It was perfectly clear that this was being pleaded as a proprietary and a personal claim.
Yeah.
And, my Lord, if you say that everything here is being can be brought in under the umbrella of proprietary, then the personal element of the claim becomes immaterial. But the fact is, as I said right at the beginning in dealing with Macmillan, the recognition was that knowledge was necessary to prove. Why is that? In order to get yourself within the confines of the duty to restore, which then opened the gates to a wider bevy of relief, or at least were perceived as doing so. So that's Lord Justice Staunton at 470, and then at 488, it's the same point again as I made a little earlier in relation to Mr. Justice Millett's judgment between F and G. As to the claim, Macmillan says it is based on obligation, not property. It describes it as a restitutionary claim, albeit based on its equitable property in the shares. The banks say that it is a proprietary claim, not one arising out of an obligation, since there was no contract or equity between the parties. Mr. Justice Millett, while accepting Macmillan's description of the claim as restitutionary, held that it was the issue that mattered and that it was one of priority of property rights.
Are you on 488?
Or 78.
Or 78.
Oh, I'm on the wrong page completely.
Right.
Sorry, did I say 488? I do.
Okay.
No, I
Don't
suspect
worry.
you didn't.
I'm so sorry.
478 F to G. Thank you.
So sorry. So this is not the argument about characterization of the claim on which the question of which law of priorities was going to be applicable. And then to actually page 488, where we see between G and H, Macmillan claim a declaration that they remain and still are beneficially entitled to the shares, a declaration that defendants hold their Burlet shares on constructive trust for the plaintiffs, and inquiries as to the compensation damages and for breach of trust and conversion and ancillary relief. Now, I accept that that is unclear as to whether there was any additional claim. But across the page at 489, at H, Macmillan submitted that their claim was in essence a claim for the performance of an obligation by the defendants to restore their property or the proceeds or the value of the property. That, it was said, was a claim in equity for restitution. That is true, but to succeed it involves establishing a number of facts, including that they owned the shares and that they were transferred to the defendants in breach of trust. And you may say, well, those are ingredients of the El Aljou claim. They are the ingredients of a knowing receipt claim.
I'm very sorry, that latest quotation was which page?
Page 489H.
H.
You see, you wouldn't need to show beyond showing that you owned the shares, you would not need to go any further if it was simply a proprietary claim. But what's been said here by Lord Justice Aldous is you've also have to show, in order to make good the claim which I'm addressing here now, is that they were transferred to you in breach of trust. So that certainly resonates with the ingredients of knowing receipt.
Well, it also resonates with the proprietary claim, because if they were transferred pursuant to the terms of the trust, then the proprietary claim would be overreached.
Because of the overreaching. That is correct. That's accepted. So I can't take any further than I have the fact that there are these references in the judgments to claims which are A, personal, and B, equitable, and C, as we say, the only game in town at this time, irrespective of the classification of the claim, was that the claim was a knowing receipt claim. And although the parties, for their respective reasons, may have wanted to classify the claim as restitutionary, Macmillan seemingly thinking that it would gain an advantage by doing that in order to get English law of priorities into play. The fact of the matter is that the court, whilst going along with that classification to a point, at the end of the day put up its hand and said, no, the issue here is the classification of the issue, not the classification of the claim. And the classification of the issue depends on questions of title. So I do say to you that Macmillan must have been a knowing receipt case. Second point is that it's abundantly clear that everything that Mr. Justice Millett said in Macmillan must be applicable to knowing receipt, because there is no suggested carve-out, and indeed as a matter of logic, reading what he says, the distinction that he is drawing between cases of privity and non-privity, if that's the distinction, then knowing receipt falls into the first category, cases of non-privity. Perhaps I should reformulate that in the correct order. The distinction he's drawing between cases of non-privity and cases of privity, it's perfectly clear that knowing receipt falls within cases of non-privity, falls within the first category, which are cases which require you to establish a continuing proprietary interest. And that was the issue in Macmillan. If it wasn't necessary to maintain a continuing proprietary interest, then the whole discussion in Macmillan was a waste of everybody's time, including the Court of Appeal's time. And by the time it got to the Court of Appeal, it wasn't necessary for the Court of Appeal to undertake an analysis of the sort, to have a discussion of the distinctions which Mr. Justice Millett had put forward, because the case proceeded on the basis that the proprietary claim was going to have the continuing proprietary interest was going to need to be established. But it's perfectly plain that the continuation of an equitable proprietary interest was absolutely central to whatever it was being claimed in Macmillan, and it's perfectly clear that what's being said in relation in Macmillan as regards the need to be able to maintain such a claim in equity must apply to knowing receipt. So, the bottom line, third point, is that even if knowing receipt, if Macmillan's not a knowing receipt case, so it's not a knowing receipt case, nevertheless, everything that's said in it is absolutely right. And finally, in relation to it, can we just step back and remember that Akers in the Supreme Court said what we're asking you to hold in this case 7 or 8 times. And it said it in relation to the in personam jurisdiction generally, and it's that jurisdiction which has been was clearly recognised by the Supreme Court as being blocked by a case where a perfect title has been taken under the lex situs, as had been recognised in Lightning. So look, that's the position in relation to Macmillan. I can't really say any more than that.
Can I just ask you? I think this may take us off at an unhelpful tangent potentially, But let's assume that you are dealing with a defendant who is an innocent volunteer.
Yes.
So not a knowing recipient. And you would accept that there is an equitable proprietary claim against the innocent volunteer who still has, let's say, the shares.
Yes.
Let's then assume that the innocent volunteer...
My lord, may I stop you for just 1 second? We're talking bona fide purchase for value here.
No, I'm not.
Well, that's why I stopped you.
Yeah.
What about, are we talking Saudi Arabian shares?
No. I'm just giving you a hypothetical situation.
So this is, forgive me, this is a situation where the innocent volunteer has taken subject to title.
This is a situation where has taken subject to title.
The volunteer has taken
Yes,
subject to the benefit.
sorry, yes. Yeah,
Thank you.
Yeah, but without knowledge or notice.
Yes.
The shares are then dissipated by the innocent volunteer,
Yes.
but the innocent volunteer has the value of those shares, but they're not traceable.
Exam question.
Well, the reason I ask is that I'm wondering whether often... So what I'm saying is your understanding that there is no claim in relation to the value that the defendant, the innocent volunteer, still has? He's not accountable for that value.
My lord, can I ask you a question back? When you say that, but he still has the value, you say,
Yes.
but it's not traceable.
Yeah.
May I please ask you how that, what the factual scenario that is that?
It may just be that he had the money, he's perhaps dissipated it on something else, but that saved him a certain amount so that one can still say that he's still benefited.
Yes.
by the. So I'm talking about value that is still
Well,
benefited.
he had a holiday.
Or he paid into an overdrawn account.
Yeah, okay.
He took a holiday.
Yeah,
No claim.
no claim.
No, that's the law. And indeed, actually, Goff and Jones covered that. I mean, it may not be great, but it's perfectly clear that that's English law. Yeah.
Okay. So that's it. That is the lacuna that unjust enrichment would seek to fill, I think, if one were ever to allow the strict liability. It strikes me as an odd lacuna, and it may just be that some of the statements being made in Macmillan, I wonder whether that is, I think we talked about this just before lunch, whether that is along the lines that was being thought of, because they often talk about subject to change of position. And I think that would indicate that they're thinking maybe there's a strict liability personal claim, not based on knowing receipt, but subject to change.
To be honest, who knows?
I did say it might be an unhelpful tangent.
It's interesting, but it is actually covered. I think the actual example is covered in Goff and Jones, isn't it?
Well, Lord Nichols gives the example in the landmark.
Okay. Well, I won't.
Yeah.
I'm referred to 2446, Lord Nichols. I believe. Goff and Jones explain.
That's showing the lacuna if one doesn't recognise a strict liability claim. Yeah.
Yeah.
Okay. Thank you.
Okay. So that's all I can say about Macmillan. But we do think what we've said in relation to it is right, in relation to it being a knowing receipt case. But we say to you, even if it is not, clearly what's being said in it does apply to knowing receipt. And frankly, at the end of the day, you've got Akers, which is, what's Akers has made perfectly clear.
Well, unless you've got anything against you, if you're right in principle, then these authorities
Don't matter.
they don't ultimately matter.
They don't. But is where I suppose what I've been saying as the justification in principle is bolstering, supporting what Mr. Justice Millett said. You may say that I have attempted to articulate, for what it's worth, I have attempted to articulate the underlying thinking supportive of the existence of the first of the two categories, as identified by Mr. Justice Millett in Macmillan. He didn't choose to explain it. I've tried to. And in our respectful submission, as we say, it is the answer in this case. Now, in the time available, I think I've said what I need to say about acres. We don't consider that there's, with respect to the appellants, there's anything in acres, frankly, for them. They say that the Court of Appeal, in its conclusion, only referred to paragraph 20 of Lord Mance's judgment. The fact is that that doesn't deprive what paragraph 20 of force, nor does it frankly recognise the fact that actually the Court of Appeal in its judgment did refer to other paragraphs of acres, the numbers to which I do not, having got out of my order, I do not immediately have to hand. But there are a series of references to paragraphs of acres in the judgment of the Court of Appeal, not merely paragraph 20. But the essential point is paragraph 20 does say it all, and if you've got any doubt about it, saying it 7 times just bangs the point home.
Yeah, well, you've said it about 7 times by now, so I think we've got the point.
Okay. And so the only other points that the appellants make in relation to acres are there's a paragraph of Lord Newburger's judgment that they refer to, paragraph 63, which we answer what they've said in relation to that in our written case. And there is a suggestion, a faint suggestion, that what Lord Sumption said in acres is somehow supportive of them. It is not. What Lord Sumption said in acres was simply concerned with recognition that the in personam jurisdiction extends to third parties as well as to two parties. And he was not suggesting that the lex situs was not relevant to determining questions of priority. He couldn't possibly have been making that suggestion because he, like all other members of the Supreme Court, signed up to Lord Mance's proposition in his judgment. We've dealt with some of these points in our written case, so I won't go back to them. So far as regards El Ajou, I've already said to your lordships that the appellant's position in relation to El Ajou is as regards El Ajou at first instance, and this is paragraphs 55 and 56 of the appellant's case. The appellant's position is that El Ajou demonstrates that if Macmillan was a knowing receipt case, then it was wrongly decided. And you have our submissions on that. El Ajou can't possibly be taken as demonstrating or establishing that Macmillan was wrongly decided. If anything, the propositions in Macmillan suggest that if there is a tension, then El Ajou was wrongly decided. But in our respectful submission, the two cases can stand perfectly tenably on the basis that El Ajou was concerned with tracing, Macmillan with title, and El Ajou was concerned with tracing against a fraudster.
Yes, I won't take up your time in studying the distinction, but I struggle to see what Mr. Justice Millett was getting at in making that point. But anyway, I think you've got other things to cover.
Yes, thank you. Well, your lordship's heard me on it. I see your lordship's point.
Are you at some point going to help me to understand what sort of knowledge makes retention or receipt unconscionable?
My Lord, no.
You're going to give me the same answer as Mr. Crowe. Such knowledge as makes it unconscionable.
No, well, I think that at one level, no. Okay, let's have a go at it. At one level, what's been said is no more than this: that if you have knowledge sufficient to bind your conscience, then it's unconscionable not to restore.
Yeah, well, that is. Yeah, it is.
Yes,
it's hopeless, isn't it? Absolutely hopeless as a legal test.
Well, let's carry on. Let's have a go at it. So if you've got such knowledge as to bind your conscience, knowledge of what? Knowledge of the breach of fiduciary duty. Okay, yeah. All right. So prima facie, that's bound your conscience, and so prima facie, it would be unconscionable for you not to restore. But it may be that there's something about the circumstances which suggests that it's not unconscionable. And that, as my own friend rightly said, may need to be investigated on any given state of facts.
But what I'm trying to understand is whether we're simply talking here about actual knowledge, or whether there's some concept, potentially, of constructive knowledge, or something that you would know if you made reasonable inquiries, or a reasonable person would appreciate, even if the actual person didn't.
Well, that goes to the question of what is the relevant test of knowledge in this particular area.
Yes,
it doesn't actually, if I may respectfully say so, go to the question of unconscionability. It goes to the question of what is sufficient to bind your conscience. The question then is, does a reference to unconscionability add anything else? Now, if you're putting it to me on the basis that knowledge is the moving part here, because once you've established the test of knowledge, you've established conscience, and then unconscionability follows automatically, then you come back to the question of, well, what is the relevant test of knowledge, and what are the facts of any particular case which lead a court to determine that a party had the requisite knowledge. Is it actual knowledge? Is it willfully shutting your eyes? Is it such knowledge as you would have had if you were a reasonable person? I think the position is, at present, in English law, that if you recklessly close your eyes, if you're willfully a default, effectively, in relation to the matter, then you're taken to have knowledge. But beyond that, you're in the realms of notice. Right. But wherever the line is drawn, but see, there's an interesting point here, isn't there? That the knowledge issue goes to your conscience being bound. Yeah. And then there's a separate question as to whether unconscionability might involve a further variable. It may be that unconscionability is saying no more than that you are conscience bound. Because after all,
I didn't think there was that extra sophistication in the test.
Yes, well, and indeed the test as expressed may be said not to involve that extra sophistication. Because what the test says, unconscionable to retain the benefit of the receipt. And so conscience, as it were, has fed into unconscionability at that point.
But we ought to be able to articulate, in agreement with what Lord Legate has said, whether the knowledge is actual or constructive. I mean, I just don't follow why it isn't possible for us to articulate that from the surveys of the authorities. My reading of the authorities would be that they are actually, by and large, accepting constructive as well as actual knowledge. So if you look at something like Akindele, on the actual facts, what became important was that they had no constructive knowledge. But it isn't really good enough of us to just sit back and say, well, a test of unconscionability is what's been laid down, and we can't do any better than that on the knowledge aspect, is it?
Well, it's not. Well, with respect, my lord, and I'll come back to your specific point on constructive knowledge. It's not actually an issue in this case, and that's why I'm being vague. I hope I haven't been vague in answer to all other questions. It's because I haven't actually prepared the point.
Just about every case on knowing receipt, and what people want to know is,
yes,
apart from the issue that we've got before us, They want to know what the level of knowledge is. I mean, we should be able to answer this, surely.
Yeah. Okay. Well, when your lordship's referring to constructive knowledge, right? Constructive knowledge clearly includes recklessness.
Yes.
Yes. So does constructive knowledge include what a reasonable man would have understood?
Yes.
Right. Well, in that case, well, your lordship, if I may say so, has answered that question on the basis of his deeper review of the authorities than I've undertaken. That if that's the law, that's the law. Now, why can't that be the answer to the question? That it remains the position that the issue before this court is is the proprietary interest required? And if I may, I do wonder, and forgive the naivety of this observation, if it's just a bad point, you'll shoot me down, but why is unconscionability so much more uncertain than reasonableness? When you say, the whole law of tort of negligence is based on the standards of a reasonable man, we all know it works, but why isn't unconscionability an equivalently discernible concept? Dishonesty for the purposes of dishonest assistance is something that the courts need to.
Well, I think this may be getting off into, again, tangents, but I would just say, because nobody knows what they mean when they say it's unconscionable. I think reasonable care, it is sufficiently clarified by the authorities that we can actually now articulate what we understand by that. But the trouble is, since unconscionability was being put forward, we're still left with this uncertainty at the core of it about the level of knowledge.
I thought that Montague, page 511, analysed the main types of knowledge and came down eventually in relation to 1, 2 and 3, but left a question mark over 4 and 5.
Yes.
Yeah.
Yes.
And
That's
and beyond that, I see the term constructive knowledge being used subsequently without any definition of what it means.
Yeah.
And
if we finish that subject, and I don't want to finish it early if you don't have to, but before we leave Elajou, you briefly, in response to a question of mine, invited me to read the beginning of Lord Justice Hoffman's judgment in a sort of cut and paste way, because, albeit not, in his oral submissions, Mr. Crowe really uses this as a big peg on which to hang his case. He said, well, they're the requirements, and it doesn't include a continuing proprietary base. And I've just got it open in front of me. It's on page 1170. And I just wonder if you could, as it were, help me understand the explanation you gave this morning with the passage open in front of us.
Yes.
And why you say it works.
Well, I say it works because if you just reading the 3 ingredients, for this purpose, the plaintiff must show, first, a disposal of the assets in breach of fiduciary duty. Secondly, the beneficial receipt by the defendant of assets which are traceable as representing the assets of the plaintiff. The assets are assets representing the assets of the plaintiff. Then thirdly, knowledge on the part of the defendant that the assets he received are traceable to a breach of fiduciary duty. What is the assets he received referring to? The assets he received are the assets which are traceable as representing the assets of the plaintiff. That's my point. So take the words which are traceable as representing the assets of the plaintiff, underline them, copy them, paste them in after the word assets in the 3rd ingredient, and you've got the answer.
would another way of doing it be to add in, under the 2nd factor, that the legal and stroke or beneficial ownership of the assets belongs to another, which I think you take as take out from the word traceable? I mean, if you were adding in words to that definition, what words would you add in to make it absolutely clear as to what case, as to the outcome of this appeal? On your case.
In a sense, Roger, thank you for that, because the way I interpret what you've said, certainly how I would take it, having heard you, is actually when you look at the second ingredient, rather than bothering with the third ingredient, you've actually got the answer there, because that's talking about the beneficial receipt, whereas the third ingredient is talking about the knowledge of the breach of trust. And so the point you're making, which with respect I now see is the better way of putting it, is and this is actually the conclusion that the Court of Appeal reached. You know, they said, look at the second ingredient. There's an ambiguity in the second ingredient. How shall we resolve it? What your Lordship is saying to me is the beneficial receipt, at this stage, you're looking at the quality of the receipt by the defendant, and what must he have received? He must have received assets which are traceable as representing the assets of the plaintiff. Therefore, he must have received assets in which the plaintiff continued to enjoy an equitable interest, understanding traceable in the conventional way in which we've been discussing it, at the same time as querying Elajou.
So if we had Lord Hoffman here and said, what if the defendant, the assets which are being claimed in the hands of the defendant are assets to which, under the applicable law relating to those assets, he has a clean title, you would say, well, then he fails on condition 2.
Yes.
Right.
Which is what the Court of Appeal said in this case.
In which case?
In our case.
In our case.
Oh, sure. Yeah.
Sorry, not in this case, Elajou. In our case, exactly. Yes, precisely. Precisely.
Rather,
Yes, I'm grateful.
Rather affects traceability as well as receipt.
It does, but if you see what Mr. Justice Millett said in Elajou at first instance in relation to traceability as concerning that the conduct of the villain alone, then you can, I think, square what he said with a general understanding of traceability. But a general understanding of traceability, I freely agree, and I'm not attempting to defend Mr. Justice Millett beyond the realms of credibility here. I freely agree that on a conventional concept of tracing, if proprietary rights have been defeated, that's the end of the ability to trace. Freely agree that. And indeed, we had an exchange. I had an exchange with the Court of Appeal on this very question. Lord Justice Newey said exactly what your Lordships have said. He found it a bit difficult to understand why Mr. Justice Millett came to the conclusion he did on this point in Elajou.
In this case, you're saying traceability is defeated because of the nature of the title conferred in Saudi Arabia.
Yeah.
Precisely.
Which calls into question Lord Millett's explanation.
Yes.
Of Elajou and Millett.
Look, that would be, as I've said, a conventional explanation of the way tracing works.
Yeah.
So it's Elajou first instance that's rogue, not the respondent's case before this court. And I'm very grateful to Lord Stevens for sorting me out on the second ingredient. So there were a few points. I mean, I've got a number of headings. Would you just bear with me for a second, please? There were a few points which I said that I was going to come back to in relation to what my learned friend said yesterday. And I had dealt with one or two of them, but I hadn't dealt, I think, with all of them.
Doesn't stop for you at 3:30.
Sorry?
the clock doesn't stop for you at 3:30.
No,
because Mr. Crowe has used up 15 minutes of his reply time.
Well,
so if you need more, if you need time to go through these points, you have them.
Oh, that's kind of you. In fact, to be fair to Mr. Crowe, he, if I may say so, he only used up 12 minutes. He was looking at me very expectant.
Thank you for your precision.
I would. One point I wanted to make to you was actually to pick up on an exchange which happened late last night, and that was that Mr. Crowe, quite late last night, thought up, if I may say so, the point about a discretionary object of a trust. And he came up with the discretionary object, and he said, well, its discretionary object doesn't have an equitable interest. How can this apply in the case of a discretionary object? And the answer is the answer that Lord Briggs gave. I mean, the fact of the matter is a discretionary object does have equitable interests under trusts. It may not be a fully fledged equitable interest in the same way that A for life, remainder to B, fixed interests are. But the discretionary object of a trust has all rights of a fixed interest beneficiary in order to hold his express trustee accountable, and similarly all equivalent rights in order to hold a knowing recipient accountable. Now, the fact of the matter is that if you've got a discretionary object bringing a claim in this context, the discretionary object will bring it in a representative capacity. But more likely still, if it's a discretionary trust case, the case will be brought by the trustees.
Yeah, the new trustees.
Exactly. Or the old trustees if their breach of trust was innocent. Depends on whether the old trustees' breach of trust was sufficiently serious for them to be removed. But let's say
in any case where the beneficiary's interest isn't an outright beneficial interest, it's mine, the relief which he's going to have to seek will in some way involve the reconstitution of the trust fund. Because if he's a remainderman, he can't have the property now, and if he's only a life tenant, he can't have it absolutely.
Precisely. So that the remedy that is sought is restoration of the fund. Do you have locus to ask for restoration of the fund? That's the question. There may be cases, you can imagine cases, where the life tenant says, I want restoration, and the remainderman says, I don't. But that's a case where the remedy will be tailored. You know, that which is restored will be held for the life tenant for life. And then the remainder interest will go to the third party because of the separate act of disposition by the remainder man. You may have a case where the remainder man says, I want it, but the life tenant says, you know, this was done with my consent. I don't want you to have to restore.
Yep.
And in that case, well, during the life of the life tenant, the income will be paid to the third party. These are acts of subsequent disposition. But there's no problem, my Lord, you're absolutely right, with a discretionary object bringing a claim in known receipt. Your Lordships have my point that the actual wrong that we're looking at here, so far as English law is concerned, is unconscionability of retention of the benefit, not simply looking at the so-called wrong of receipt, as after acquired knowledge demonstrates. There is an interesting, in relation to unconscionability and in relation perhaps to the question of whether trust property is necessary in the hands of a known recipient, there's an interesting 3 paragraphs in a decision of this court given at around the same time as Akers. And it's a case called Angove's Property Limited versus Bailey. It's a case where the Supreme Court repudiated what had been said about quisclosed trusts in a case called Neste Oy. And if we could just look very, very, very quickly at that, please. The case is at 702 and following, but the paragraphs, Lord Sumption's paragraphs at 27 to 29 are at pages 714 to 715. And at paragraphs 27 to 28, he makes an observation, which ends up with a wry observation. in relation perhaps to which might be thought to resonate with your lordship's slight frustration with the concept of unconscionability in this context. He says at 27 on 714, English law is generally averse to the discretionary adjustment of property rights and does not recognise the remedial constructive trust favoured in some other jurisdictions, notably the US. It's recognised only the institutional constructive trust, Westdeutsche. In the former case, the difference was explained by Lord Brown-Wilkinson in the following terms. Under an institutional constructive trust, the trust arises by operation of law as from the date of the circumstances which give rise to it. The function of the court is merely to declare that such trust has arisen in the past. The consequences that flow from such trust have arisen, etc., are also determined by rules of law, not under discretion. A remedial constructive trust, as I understand it, is different. It is a judicial remedy giving rise to an enforceable obligation. Then he says at 28, and this is what we pick up, he says that Justice Bingham's point of departure in Neste Oy was that the recipient of money may be liable to account for it as a constructive trustee if he cannot in good conscience assert his own beneficial interest in the money as against some other person of whose rights he's aware. As a general proposition, this is plainly right, but it is not a sufficient statement of the test because it begs the question what good conscience requires. Property rights are fixed and ascertainable rights. Whether they exist in a given case depends on settled principles, even in equity. I think that's a dig, I think. Good conscience, therefore, involves more than a judgment of the relative moral merits of the parties. And we cite this to you because it really underpins a lot of the discussion that we've had in this case. The Appellants case, essentially, this is all about good conscience. Don't bother about property. But the point that Lord Sumption was making in this case was that you can't be as random as that in the way in which you approach these matters. You've got to look at property rights in order to decide whether someone is conscience bound or not. And then at 29, there's an interesting statement which mirrors a statement in Westdeutsche. In English law, one of the essential requisites for a trust of whatever kind is that there must be identifiable trust property, or its proceeds, in the hands of the recipient, which are not available to him as part of his general assets, Westdeutsche. The only true exception to this is the case of a person liable to account as a constructive trustee, note, not as if a constructive trustee, as a constructive trustee, on the ground of his dishonest assistance in a breach of trust. This is a terribly interesting statement because it's a recognition. It's clearly dealing with the third-party case as well as the two-party case because it's referring to dishonest assistance. And it's a recognition that in a knowing receipt case, an implicit recognition, I accept, in a knowing receipt case, there has to be trust property in the hands of the recipient party in order for that recipient party to be liable. And by trust property, it's property subject to trust rights, it's property subject to a continuing equitable interest, we would suggest. Now, I don't want to read too much into it, but it is an interesting observation, and it's the more interesting one might, well, the interest in it is affirmed by the fact that it's exactly the same point as Lord Brown-Wilkinson had made in Westdeutsche at 2076 at page 705.3. Now, Angove wasn't a knowing receipt case. Please don't misunderstand me. Far from it. It was a principal and agent case. The issue was whether a constructive trust in favour of the principal could be imposed on instalments of customer monies collected by an agent following its going into administration in circumstances where, in the ordinary course of business, there was merely a debtor-creditor relationship between the parties. So it wasn't a name receipt case. But it is interesting to see Lord Sumption, in conjunction with his observation at 28, making the point at 29. And as I say, it's the same point made by Lord Brown Wilkinson in West Deutsche at 705.3. It's plain that 29 is not merely dealing with two-party cases. If it was, then that would be the answer. But it's not. And then please, if you don't mind, bearing with me.
So if you were to give Mr. Crowe his 18 minutes, you'd have 4.
No, I'm really, really sorry. So much has been, well, your lordships know, so much has been taken out of perceived step. I take it that your lordships are not minded to wade in on land registration, on land registration in this case. I mean, obviously, your decision will have.
We have the written submission.
Yes. Yes.
I wouldn't personally promise not to mention it. Not least because it's an English law situation, which, if you like, maps the foreign law barring a title.
Yes.
I noticed the Court of Appeal also referred to Section 2 of the Law of Property Act.
They did, and but that was I did argue the case of overreaching in front of them.
Yeah.
And of course that does create an equivalent issue. What I said before the Court of Appeal is that there are a number of different situations in which equitable interests may be effectively extinguished.
Yeah.
One is the conventional overriding of such interests, as we've been discussing, for example, by bona fide purchase. Another is by operation of a registration system.
Yeah.
And a third is by the operation of the law of overreaching, which may not necessarily involve an authorized transaction, is what I said.
I'm not quite sure it's overreaching or overriding, but it doesn't matter.
No, yeah, but as your lordship said when correcting himself with my own friend yesterday, they are distinct concepts.
Yeah.
And of course, if you're acting within the course of your powers and duties as a trustee, then if it's a proper transaction, then the beneficiary's interests are overreached, and yes, they're translated into money or whatever other property is received. But what's interesting about, for example, Section 2 of the Law of Property Act is that you may have a transaction which does involve a breach of duty, but which, because the purchase money has been paid to two individual trustees or a trust corporation, has the effect of converting the beneficiary's interest from an interest in the property which is passed to the third party to an interest in the money.
Yeah.
And in that circumstance, yes, I did submit. In that circumstance, that's another case where the interest of the beneficiary is extinguished.
Well, that's
and
what the Court of Appeal said. Yeah.
Yes, that was the submission that they were.
That's the overreaching by reason of the statute.
Precisely, and then you get into questions, because you've then got to ask what does the statute actually say in terms of the rights of the third party in that case? Does the statute say? And I think, my Lord Briggs, you deal with this actually in your article, your critique of Acres.
I thought I had hoped to escape any mention of it.
In the lecture you gave to the Chancery Bar Association, you then get into the question of whether the third party, as a purchaser, needs to be, under the legislation, a bona fide purchaser. And it may well be that you've paid your purchase money to two individual trustees, but the overreaching will not occur unless you're a bona fide purchaser. So you then get into a further question. That's in Section 205(1) of the Law of Property Act. So you then get into a further question as to whether the particular statutory regime which provides for overreaching gives benefited purchasers a let out, or other people a let out. All very interesting, and certainly equivalent to this particular case. Overreaching is equivalent to this case. Unless I can assist your lordships further, I think I've used up all my time.
Thank you very much.
Thank you.
Mr. Crowe, you have exactly your 18 minutes.
I'm grateful if I could use them efficiently. The narrow issue in front of you could be characterised in a sense as a way of asking, well, what is the function of knowing receipt and what is the principle by reference to which it works? If you take the view that knowing receipt is, in a sense, a vindication of property rights, and the principle by reference to which it operates is the principle of equitable ownership, then I apprehend that we will not be succeeding on this appeal. If you take the view that knowing receipt is a form of ancillary liability that is ancillary to the primary breach of trust, and that its function is remedial, we apprehend that we will succeed. Another way of putting that question is to say, what is the equity? We often see reference to the equity, either being extinguished or not being extinguished. If you regard the only equity that is capable of being considered as beneficial ownership of the property, then that answers your question. But if you regard the equity as a description of the way in which equity can operate and does operate on the conscience of recipients, then what you're looking at is the circumstances of the receipt and the question whether or not equity should provide a remedy. And in relation to that, the couple of very short passages which I mentioned but didn't read to you in opening in Williams, at 529, please. Paragraph 9, Lord Sumption has quoted Barnes and Addy, and at paragraph 9 he says, "It is clear that Lord Selborne regarded as a constructive trustee any person who was not an express trustee but might be made liable in equity to account for the trust assets as if he was." And then explaining the different usages of constructive trust on the last 3 lines of the page. In its second meaning, the phrase constructive trustees refers to something else, that is not a true trustee or somebody who's received trust assets lawfully. It comprises persons who never assumed and never intended to assume the status of a trustee, whether formally or informally, but have exposed themselves to equitable remedies by virtue of their participation in the unlawful misapplication of trust assets. Either they have dishonestly assisted in a misapplication of the funds by the trustee, or they have received trust assets knowing that the transfer to them was a breach of trust. In either case, they may be required by equity to account as if they were trustees or fiduciaries, although they are not. These can conveniently be called cases of ancillary liability. And then 2 lines down, it is purely remedial. And then 2 lines below that, in the words of Lord Justice Millett in Paragon, the distinction between an institutional trust and a remedial formula, between a trust and a catchphrase. And just also at 532, paragraph 14, he cites the case of Hovenden and Lord Annesley, and we would emphasise that the concept of making somebody personally liable to account on the basis of knowing receipt as a constructive trustee is described at letter E. Trust is to be constituted as a trustee by a decree of a court of equity founded on the fraud. It is not a recognition by a court of equity of a continuing beneficial ownership. It is a construct imposed by the court because of the fact of receipt and misconduct of whatever nature is required. And in the next paragraph, the position of a person who is not an express or a de facto trustee, but is constituted a trustee by a decree of the court, may be illustrated by other cases. And finally, page 540, paragraph 31, the essence of a liability to account on the footing of knowing receipt is that the defendant has accepted trust assets knowing that they were transferred to him in breach of trust and that he had no rights to receive them. The essence, my lords, is not that he holds something that still belongs to someone else. It is the knowing receipt liability is a personal liability to account because someone, through knowing receipt, has, to that extent, to use my Lord Barrow's phrase, participated in a breach of trust in the sense that he is a knowing recipient of the proceeds of that breach of trust. The second point I just wanted to urge on you is that in choosing between the competing lines of argument that have been offered to you, we would suggest to you that one of the tests, so to speak, you may wish to apply is which side is offering an argument which has greater internal coherence. In our submission, it was striking when my learned friend sought to rationalise the outcome in cases involving companies. He didn't get onto Crown land, but dealing with companies, he started by accepting that his case was based on a fiction, which he then retracted, and said it was based on an analogy, which he's then moved away from, and is now relying on a concept of a sort of deemed severance between a legal and an equitable title. The fact that in the space of only 2 days of oral argument there have been 3 alternative explanations in our submission raises a question mark as to the coherence of that whole line of argument. Similarly, the position in relation to discretionary beneficiaries raises the question, well, how can it be that the defining requirement in knowing receipt is beneficial ownership of the property transferred in the hands of the recipient remaining with a claimant? In our submission, our analysis is entirely coherent and consistent because it is based on the principle that personal liability is visited on a knowing recipient where they receive property knowing it has been transferred in breach of a fiduciary duty in relation to the stewardship of that property. And that explains trust cases properly so called, company cases, and cases involving a transfer of Crown land. And we would submit it also dovetails the fact that on our analysis, the defining characteristic is a transfer in breach of fiduciary duty. That dovetails with the other elements that we identified in opening, namely that the relevant knowledge is not knowledge of a prior title, but knowledge, repeatedly the cases say, knowledge of the breach of fiduciary duty. And it dovetails with the requirement we see in the receivership cases like Brown and Bennett, that the transfer has to be the direct consequence of that breach of fiduciary duty. None of those refinements would be necessary if this was a pure question of vindicating a pre-existing property right. And indeed, the very heterodoxy of my learned friend's argument then started emerging when he had to accept that the logic, following the logic of his own argument, he said, we don't have to use these labels, but he said, in one sense, what we call a knowing receipt actually involves a true trust, because the claimant is pursuing property which still belongs to them under the original beneficial ownership. And in our submission, that analysis, the idea that knowing receipt represents a vindication of a pre-existing beneficial ownership in the claimant, is wholly inconsistent with the kind of language we just saw in Williams, but we've also seen in Solanger, West Deutsche, and many others, which talk about the imposition of liability by the court based on the recipient's conduct. It is not a recognition by the court of a pre-existing state of affairs, namely beneficial ownership in the plaintiff. It is the imposition of a construct. That's why the word constructive trust came about. It's a court-made construct to impose personal liability because of the defendant's behaviour. And indeed, my learned friend, following the logic of his own argument, to do him credit, had to accept that in one sense, he said, no, the law on knowing receipt has taken a wrong turn, in that he would say that it should simply have been recognised as the vindication of pre-existing property rights, in which case all the case law that we've been looking at has been approaching this from essentially the wrong angle. And in our submission, that level of heresy is not one that you should espouse. Next point I just wanted to make in relation, as my Lord Briggs said, we do rely on the formulation in El Ajou.
That's the Hoffman formulation.
Of course, the Lord Justice Hoffman formulation. Yes, the word tracing is used, but we know tracing, and this was said by Mr. Justice Millett in El Ajou itself, tracing isn't a remedy, let alone a proprietary remedy. It's a process. It is a process for identifying property and where it's gone. It is as necessary in a knowing receipt case as it is in a proprietary case, because in knowing receipt, what the claimant has to show is that the property in the defendant's hands is the transfer of the property to the defendant is the direct consequence of the breach of trust on which the liability is said to be based. So tracing is a purely evidential process to identify whether or not the property in the defendant's hands represents the proceeds of the fraud. So the fact that Lord Justice Hoffman used tracing in that does not mean beneficial ownership in the claimant is a precondition to a claim in knowing receipt succeeding. It would be, with respect, astonishing if Lord Justice Hoffman had intended to convey that a continuing beneficial ownership was a precondition to any claim in knowing receipt succeeding without saying so in terms. And no one else has put that gloss. That paragraph has been quoted over and over again. Nobody has put the gloss on it that my learned friend would wish you to add to it. The next point, very quickly, we just wanted, I know my learned friend and I may seem a little obdurate in response to my Lord Legate's questions about knowledge, but can I just remind the court about what the Statement of Facts and Issues actually says, because it's relevant in two respects. One, to identify the narrowness of the issue, and the second, to identify the remarkable position which the respondents are inviting you to take. So if we could go in the bundle at page 50. We have the underlying facts. And I know it's very brief and you will have read it, but just to remind you, paragraph 3.2, on or about the 16th of September 2009, Mr. Alcinea transferred the disputed securities to Samba. He did so in breach of trust. At the time of Samba's receipt of the disputed securities, it knew that Mr. Alcinea was holding the disputed securities on trust for SICL, and a reasonable bank in Samba's position would have appreciated that, alternatively, would or ought to have made inquiries or sought advice which would have revealed the probability that the September transfer was a breach of trust, and or Samba recklessly failed to make such inquiries about the September transfer and the disputed securities as an honest and reasonable bank would make. And moving to para 5, it is not in dispute for the purposes of this appeal that if SICL had had a continuing proprietary interest in the disputed securities following the September transfer, those words obviously were included to reflect Milan Friend's argument, it's not in dispute that Samber's knowledge would have been sufficient to satisfy the requirement for the purposes of a knowing receipt claim that the recipient's state of knowledge should be such as to make it unconscionable to retain the benefit of the receipt. Now, Milan Friend gave you a peroration about the importance of certainty in business. If this appeal is dismissed, the certainty in this particular business transaction is that Saudi National Bank will be able to retain the benefit of a transfer which they knew was coming to them in breach of trust. If equity can't do anything about that simply because title in the shares is registered in the name of the Saudi National Bank, then equity has failed in the face of legal title. And that, in our submission, is precisely the reverse of the outcome that should be produced. Equity is exactly there to produce equitable outcomes, despite what legal title might say. Next point, very briefly, my own friend did mention in this context a number of cases that are in his written case, Midland Bank and Green, Lloyd and Dugdale, Griggs Group and Evans, which are cases where it was held to be not unconscionable for a party to rely on registered title. All of that is true in relation to proprietary claims. They were all claims to the property. Angove, my lone friend just mentioned a moment ago, is obiter. In one sense, it's doubly obiter, and it's also somewhat opaque, because Lord Sumption referred to the only true exception to the requirement for a continuing proprietary interest, that leaves entirely unanswered. Are there things that are not true exceptions? It really, when it's dealing, it's another illustration of how difficult and potentially dangerous it is to try hanging too much weight on obiter dicta.
Well, he is contradicting what he said in Williams.
Yeah.
Indeed, he is, and given that the Williams judgment with which Lord Newberger and Lord Hughes agreed it was ratio in relation to the point, we would ask you to prefer that analysis to...
I may have signed up to Ango's, but at least to the ratio.
Very lastly, just not a submission, but simply an answer to a question. My Lord Burrows yesterday asked, when I listed various different usages of knowing receipt, my Lord Burrows asked for an actual example of a case where the expression had been used to describe a person who receives trust property lawfully, but then deals with it inconsistently with the trust. There isn't in the bundle a reported case on those facts, but that very example is actually used by Mr. Justice Millett in AGIP at 687F to H. If time had permitted, we would have said much about Acres and El Adju. I would just leave you with one thought on Acres, which is that it was self-evidently not dealing with the issue in this case. It was dealing with a purely, in a sense, a point of statutory interpretation as to whether the transfer of the shares to Samba involved a disposition within Section 127 of the Insolvency Act. The issues before you are not dealt with. The only passages in which the possibility of equitable remedies against transferees are actually discussed are in paragraphs 85, 86, and 89, where, in our view, the door is left wide open, which no doubt is why my predecessors pleaded the case as they did. So far as Elajou and Macmillan is concerned, you have already heard a great deal, and I think I have run out of time. We would simply remind your lordships that in relation to identifying what Macmillan was about, insofar as reference is made to a personal claim, it would appear what was actually being talked about was the claim in restitution. The only two labels that are used are proprietary claim and restitution. It is the fact that none of the relevant authorities on knowing receipt were cited. Melanfan says it's inconceivable that so many talented counsel could have missed the point, but with respect, that's exactly what Mr. Justice Millett said had happened in the epilogue. They had missed a point. They were bounced into an unbearably busy long trial too quickly. My Lords, can I just check if there's anything else where I could trespass? I'm very grateful.
Yes. Thank you. Could I just remind Council that we're expecting written submissions on criterion. Would 7 days be sufficient?
It would be welcome in the sense that if you give us 14 days, we'll write more.
We'll give you 14. Second 7.
7, no.
7 and 7.
7, I think, and simultaneous exchange rather than sequential.
Yes.
I'm grateful.
Yes. Thank you very much. Well, it only remains for Court to thank Council for their submissions, and if I may say so, this has been a well-argued case. I'm very grateful. Also, the Court would like to thank those who have assisted Council in the preparation of their case and the preparation of the documents for this hearing. The Court will consider the submissions in what is an important case in the law of equity and will produce a judgment in due course. Thank you.